Everyone to this employment law session. Welcome to this session, everyone. I am the employment lawyer, Lior Samfiru. Thank you so much for joining me. I'm one of the founding partners of Samfiru Tumarkin LLP. You can find us in Ontario, in BC, and in Alberta. Our biggest area of practice is employment law. We're the ones you come to if you have an employment law issue, a workplace problems, a deadline, an ultimatum. You get it. If it has to do with employment law, we deal with it. And on this session, on this live stream, I answer your questions. I tell you what you need to know about this very important topic. Your workplace rights, what you need to know if you lost your job. A lot of people have been contacting me since the beginning of the year because they lost your job. There's a lot of those things happening right now. Well, you need to know what to do, what you're owed. Chances are, if you lost your job, you've been wrongfully dismissed. Over 90% of people, when they lose their job, they're wrongfully dismissed because they're owed much more than what the company is offering them. So if you have a question about that, ask right now. If you have a question about your job being changed, your hours, your pay, your compensation structure, ask it. Tell me what you are going through, and I'll tell you what the law says. I'll tell you what you can do and what you cannot do. This is the place to get those answers and hopefully feel better about your workplace rights. That's the name of the game. You understanding your situation. And of course, beyond this session, if you want to connect with me and my team, so easy to do. You just go to employmentlawyer.ca. You see that address on the screen, employmentlawyer.ca. Why do you go there? Well, you go there because phone number is there, email address is there if you want to send an email. You can also read a lot more about employment law and find out more about your rights. So it's kind of your one-stop shop with anything employment law. It's employmentlawyer.ca. But right now, on this session, if you're watching me on YouTube, on Facebook, on Indeed, etc., I am live. You can get your answers right now. You can get those questions answered. So you have a box on your screen. You type in your question, you hit enter, and you sit back and you let me do the rest. I'll see the question, I'll read it, I'll answer it, and you can walk away with all the information that you need. So I'm going to start answering questions right now. Last couple weeks, very busy weeks, lots and lots of questions. Let's keep that going today. I want to answer as many questions as possible. If there's 10, if there's 20, if there's 50, I'll answer them all. Okay, so ask them right now. And I'm going to start. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, live here answering your employment law questions. Our first question today comes from Frank. Frank says, will money you have earned from employment before you are terminated be deducted from the amount of severance pay you're entitled to? No, absolutely not. So money that you've earned before is money that you've earned to the date of termination. Severance refers to payment post-termination, after termination. So no, your severance is not going to be reduced or affected by what you're owed. They're going to have to pay whatever you've earned to the date of termination, and then severance is on top of that. But I want you to remember, doesn't matter if you just started a job, doesn't matter if you worked there for 30 years, if you're young or old, if you're full-time or part-time, you are owed severance if you lost your job, number one. Number two, if the company's offered you something, it's probably a lot less than what you're owed. In 90% of these cases, 90%, that's pretty much in every one of those cases when someone loses their job, whatever they've been offered is a lot less than what the law says they are owed. So that's why you call me, you come on here, you send an email, you make a phone call, you reach out somehow so that we can make sure you don't accept that inadequate severance offer, that you get what you're legally owed. Okay, so right now you can get that question answered, and of course to reach out to me off air, employmentlawyer.ca. But right now I'm going to continue answering questions. Next question, Stacy, 1983. I was employed for 4.5 years. Starting 3 years ago, my management started inappropriately speaking about me. Name calling, GM told colleagues sexual comments about me. My pay was sabotaged and I was isolated with less than favorable working conditions. Then when I started, I quit. Do I have any right to damages? Absolutely. Everything you've just described is completely illegal. okay? The bad mouthing you, but the telling people, making sexual comments about you, isolating you, changing your pay, all of that is one big bowl of illegality. It's not allowed. That could be a human rights violation, constructive dismissal. In other words, even though you quit, the law would consider that as a termination. Why? Because your employer put you in a situation where any reasonable person would have left. So yes, you potentially are owed human rights damages, you're owed severance. There could be other damages as well. So Stacy, you got to call me. Your employer cannot do any of these things. Your employer has to protect you from being mistreated, from bullying, from harassment. Not only they can't treat you badly, they actually have to physically protect you from those types of things. And of course, your employer cannot just unilaterally change the terms of employment. Again, that's what a constructive dismissal is. So everything you've described that your employer did here, Stacy, illegal. So next step, of course, reach out to me. All right, connect with me through employmentlawyer.ca. Again, employmentlawyer.ca. Phone number and email address are there. Let's get you what you're owed. Great question. I'm sorry you had to go through that, but now you know that it's illegal and you know what to do about it. Great question. So thank you for that. See how easy and how important it is to ask those questions. Again, if you've just joined us, my name is Lior Samfiru. I'm the employment lawyer with Samfiru Tumarkin LLP. Why am I here? As you've seen, I'm here live answering your employment law questions. That's the only reason why I'm here. So keep asking them. A bunch of questions just came in. I love it. I'm going to answer them right now. Ask yours. You still have plenty of time. Liz has our next question. Liz asks, how complicated is it to file a human rights discrimination claim on my own? Well, it's not complicated to file it. You fill out a piece of paper and you file it. That's easy. What's more complicated is to properly advance it, to know the right arguments to make, to know how to properly resolve it, to know how to get the best resolution and how to present your case in the best possible way. Very important. You remember, if you file a human rights complaint against the company is going to have their lawyer representing them. So you're going to be up on your own against the lawyer. And that's not even a fair fight. Okay. So can you do it on your own? You can. You can build a house on your own. It doesn't mean it's going to be a good house. So Liz, I wouldn't recommend doing that on your own. You need legal representation for that. Okay. It's just to resolve the matter, to resolve it on good terms, to advance your case properly, to make sure that you do it the right way. Okay. We need to do this properly. In fact, there may actually be a better way to advance your case than a human rights complaint. There may be not even required. There may be a much faster, better, more efficient way. So Liz, you want to connect with me and my team as soon as you can through employmentlawyer.ca. Again, employmentlawyer.ca. So hopefully that answers that question. Again, employmentlawyer.ca. Happy to connect with you and talk specifically about your case. Great question. Thank you. Keep them coming. Employment law, that's what we're answering. Jeff has a question. Do you answer questions pertaining to Ontario? I'm in Ontario right now. Yes. If you're in Ontario, in BC, or in Alberta, ask your questions. That's what I'm here to do. That's why they call me the employment lawyer. So ask your question right now. Let's talk about it. Again, my name is Lior Samfiru, the employment lawyer. Let's answer more questions. Bunch of questions coming in. Love it. Keep them coming. AB1. How many years of service the employee must have to be entitled to severance in Ontario? Great question. The answer is all employees are entitled to severance. If you had a job and you lost your job, you're entitled to severance. Doesn't matter if you work for 4 months, for 6 years, for 50 years, you're owed severance. Not only that, I'm going to say something else, AB1. Short service employees, so employees that have worked for 2-3 years or less, are actually treated better than longer service employees when it comes to severance. So you could have only worked for a company for a few months. You're still going to be potentially owed a few months severance if you lost your job. You could have worked for 4 months and be owed 4 months severance. So that's the way the law works. So a lot of people think you have to work a minimum number of years to get severance. No, false, wrong. If you had a job and you lost that job, you're owed severance, unless, of course, you did something terrible. You stole, you committed fraud, you committed sexual assault. Obviously, if you did that, you're not going to be owed severance. But unless you did something horrible, something terrible, If you lost your job, you're going to be owed severance. And that severance can be as much as 24 months pay. AB1, I think this is a good time to tell you and to tell anyone watching, everyone watching, how you can find out yourself how much severance you are owed. Very, very easy to do. If you want to know right now how much severance you're owed, here's what you do. You go to pocketemploymentlawyer.ca. Grab your smartphone, your tablet, and go to pocketemploymentlawyer.ca. That address is on the screen right now. When you go there, you'll see our severance calculator tool. Ta-da! That's what you need, the severance calculator. You click on that, you answer a few questions, and it's going to tell you how much severance you are owed. It's completely free. It's completely anonymous. Over 2 million people across Canada have used it. So if you want to know how much you're owed, what a good place to start. Go to pocketemploymentlawyer.ca, use the severance calculator, and get an assessment and an estimate of the amount of severance that the law says you are owed. Again, completely free, completely anonymous. If you lost your job, if you're worried about losing your job, if you're just curious, that's what you go to, pocketemploymentlawyer.ca. So thank you for that. Continuing to come. Oh, great. Questions coming in. I love that. It's going to be another one of those days where I get a lot of questions. Makes me very happy. But you have time still. Ask your question right now so I can see it. Don't ask it in the last minute because I'll miss it. Ask it right now. You have time. Let's make sure that you walk away with answers. All right. Just like Jules. Jules has our next question. Is it appropriate for your manager to as what do you need to ask, presumably you ask it, to ask what do you need the money for upon failing to pay you? There and after, I suffered ongoing aggression to the point of harassing and being physically assaulted. Well, first of all, this is not a question, is it appropriate to ask? I mean, we don't deal here in appropriate or not. It's simply a question of legality. Your employer has to pay you what they owe you, full stop. Doesn't matter if you're rich and you don't really need the money, or if you desperately need the money to pay your rent, they have to pay you what they owe you when they owe it to you. Full stop. There's no exceptions to that. Beyond that, if you're being harassed, bullied, assaulted, that's a criminal matter too. You can't be assaulted. You should report that to the police. So everything you've described certainly could be a constructive dismissal. If your employer is not paying you or properly or mistreating you, that's a constructive dismissal. If you're being assaulted, that's assault. That's a criminal violation. You should go to the police immediately. But if you want to pursue a constructive dismissal, call me or email me. You can do that through employmentlawyer.ca, Jules. Again, employmentlawyer.ca. Yeah, very illegal, everything you've just described there. One of the most basic obligations that an employer has is to pay you what they owe you on the date that they're supposed to pay it. And they should not be allowed to get away with not doing that. You have to go to work, do your job. They have to pay you what they owe you. It's as simple as that. Thank you for that question. Love that question. Very important. Again, if you've just joined the session right now and you're wondering who I am, welcome, first of all. My name is Lior Samfiru. I'm the employment lawyer, and I'm with Samfiru Tumarkin LLP, and I'm here live answering employment law questions. If you have a question, you just joined us, lucky day for you. Ask the question. You see the box on the screen, type it, hit enter. I'll see it, I'll read it, I'll answer it. Just like our next question from Vanessa. I have a manager that has been coming down on me hard, making it difficult to do my work because I feel like I'm being forced out. I'm wondering if an employer can ask you what symptoms you're having when you're calling in sick. So no, your employer cannot ask you what the symptoms are, but they can ask you for a doctor's note. So if they want to know if you can work or not, they can ask for a doctor's note. The doctor's note doesn't have to say what the symptoms are. It doesn't matter if the reason you're missing, you have the flu. What matters is whether or not you can work. So your doctor, the doctor has to say is whether you can work or not. Now, in this particular situation, Vanessa, if it's making it difficult to continue working what they're doing, as long as you can prove that, as long as it's not your word against someone else's, that could be a constructive dismissal. You may be able to decide to leave and still get the company to pay you your full severance. So what I would consider that, the other thing you can do is tell HR management, the appropriate person, that you're being mistreated in writing. Send them an email, detail, here's what this person is doing, here's what they did on these dates. Once you do that, the company is legally obligated to investigate and then to take action to fix the situation. They are not allowed to ignore it. So, Vanessa, that could be a constructive dismissal. You have the ability to force the company to deal with the situation. And of course, when it comes to being sick, the company doesn't have a right to know what your condition is, but they do have a right to get a doctor's note to say that you're not able to work. Hopefully that makes sense, Vanessa. If you have a follow-up question, please ask it. Happy to answer it. Okay. Let's see. Next question from Cuppy J. Love the name. My employer my employer gave me, I think you mean, two options: a performance improvement plan or quit my job. My attorney sent a demand letter and my employer has now rescinded it. Can they avoid liability by just avoiding to terminate? Well, I mean, if they rescinded it, then they've done nothing wrong. Your lawyer accomplished what your lawyer wanted to do, which is to get rid of that. So I'm not sure. Okay, I guess you say you already quit. So I would need to know more. How did you quit? What did you say when you quit? How long ago it was? But if you have a lawyer, probably the best person, Kapi, to ask those questions is your lawyer. Okay, I don't want to step on anyone's toes. You should talk to your lawyer. Next question is from Sheila. I have an employer who went off sick. I have an employee, who went off sick her first week of employment. She provided a doctor's note to support the absence. She shared she is pregnant. She's going to be off regularly. Okay, you haven't asked a question, Sheila, but I think you're probably asking, what do you do about it? Well, here's the thing. You cannot do anything about it. If you try to let her go or do anything like that, that could be a human rights violation, an employment standards violation. You absolutely don't want to do that. So what do? You give her the time off that she needs. As long as it's supported with the doctor's note, you have to give that time off. Yes, I can understand that it's going to cause problems and administrative issues, etc. But the law is very, very clear on this. You have to accommodate. You have, if she needs time off, supported by a doctor's note, you have to provide it. When she needs to take her parental leave, you have to allow her to take that and bring her back. As long as there's a job there, you have to bring her back. So that's what you do. If you do anything else, if you say, well, this is too much of a pain, or you just started, so we don't want you here anymore, you're going to face several kinds of legal action. I would not recommend that at all. If you want to have a chat with me more in depth about the situation, Sheila, happy to do that. You can connect with me and my team through employmentlawyer.ca. Again, employmentlawyer.ca. Thank you for that question. By the way, if you're an employer and you want to know your rights, your obligations, what a good place to ask right now. I'm going to continue answering questions. Still have 12 minutes or so to go. Plenty of time for you to ask your question with me, Lior Samfiru, the employment lawyer. Let's make sure we get questions answered on this session. Next question comes from Happy. What a great name, Happy. We should all be happy. I believe I am going to be let go. My employer has been making major cuts, and I think I'm next. I've been there for 2.5 years and have a highly specialized role. Would I only be entitled to 2 weeks of severance? Absolutely not. Now, I don't know your job or exactly your role, but you could easily be owed anywhere from 3 to 6 months of severance, even more than that, depending on your age and your role. So no, there's that misconception that people believe a week per year or 2 weeks per year. Nonsense. No, not even close. So you've been there for 2.5 years. You're probably going to be anywhere from that 3 months to 6 months, depending on your job and your age. So Happy, no. If you're let go, they're allowed to let you go. Whether we like the reason or whether we agree or not with the reason, they can let you go. But they're going to have to pay you your severance. As soon as you're let go, as soon as you're holding that piece of paper, you call me or you email me. Again, you go to employmentlawyer.ca. We'll sit down. We'll review what they've offered you. We'll review all the terms. I'll assess what you're owed, and then we'll help you get what you're owed. Guess what? It's not difficult to get what you're owed. It doesn't take a long time. It's not hard to do. Okay? So as soon as you lose your job, Happy, you contact me again through employmentlawyer.ca. Employmentlawyer.ca. Okay. So Jules, as I said, you know how to reach me through employmentlawyer.ca. Our next question comes from Anna. Anna says, my employer is not helping me to claim my injury at work. They laid me off and still not willing to help me claim my injury through the insurance. What should I do to claim my injury at work? So your employer doesn't actually have to help you. They give you a form, but you can get that form on your own. It's your doctor really that should be helping you fill out the right paperwork to get compensated for those injuries at work. You can apply to workers' compensation. Again, obviously, it'd be nice for your employer to help you, but they don't have to help you. They can't stop you. They cannot prevent you or threaten you. But they don't have to help you. Your doctor will help you, and your doctor would have done this a million times, so your doctor knows exactly what he or she is doing. So talk to your doctor there. So you go off work with your doctor's note. When you're ready to come back to work, whether it's in a month, in a year, however long, if your employer won't take you back, you call me. You call me right away. To connect with me, of course, employmentlawyer.ca. But for now, speak to your doctor. Your doctor's going to help you fill out the proper forms. It's not a complicated thing, and your doctor would have done it before. Hopefully that makes sense, Anna. Any issues, follow-ups, you know what to do. Reach me through employmentlawyer.ca. All right, great questions today. If you're just joining us for the last 10 minutes or so, welcome. Thank you for joining. My name is Lior Samfiru, the employment lawyer. I'm here live, as you see, answering employment law questions, your workplace rights, your job, your severance, your boss mistreating you, etc. If you have an employment law issue, a workplace issue, a workplace problem, ask me what to do about it. And just like I've been telling people for the last 20 minutes or so, I'll tell you as well. Just like Frank, who has our next question. Frank asks, where is Frank? Here we go. Can my employer convert my compensation? Convert my compensation from salary to hourly? The answer is no. Well, let's take a step back. You can't physically stop your employer from doing that, but because it's not legal, you can treat that potentially as a constructive dismissal. Changing the way you're getting paid is a very big deal. Changing you from salary to hourly, again, it's a very big deal. So if your employer decides, we don't care, we're going to change you, we don't want to pay you salary, we want to pay you hourly, you have two options. Option number one is you can accept it, of course, and continue working. Sure, you can do that. Option number two is you can consider that a constructive dismissal. In other words, by changing the way you're paid, you're going to consider that to be a termination of your employment. And now you're going to force your employer to pay you your full severance. So you have that option. If that is what you want to do, okay, before you do anything, before you walk away, before you say anything, I want you to connect with me, okay? We have to do this right. And of course, to connect with me, employmentlawyer.ca, Frank. So again, employmentlawyer.ca. A few more questions came in. I'm going to answer them right now. I love it. You still have time, by the way, to ask your question. Stevie asks, if you feel that you're in a toxic work environment, how do you go about proving this, and what steps should you take? So first of all, if you're in a toxic work environment, there has to be a way to prove it. So if someone says something to you, write it down, in a journal or something. So on February 21 at 1:25 p.m., this is what happened. And so write it contemporaneously. You may even be able to record it. If you're speaking to someone, you can record it. You don't have to tell them that you're recording it. So a recording. Maybe there's a witness that is willing to corroborate what you're saying. And of course, if you're in a toxic work environment, you want to tell something about it. HR, the owner, whoever the right person is in your workplace, let them know. Tell them, because they have an obligation to try to fix that. Okay, in writing, put that in writing. And by the way, by putting it in writing, it also gives you credibility later on if you need to prove it, because it shows you didn't make it up. You actually try to deal with it. You put that in writing. So those are all ways, Stevie, to try to prove that toxic work environment. But, and by the way, if nothing is done, that could be a constructive dismissal. Depending on the situation, it can also be a human rights violation. So there you go, Stevie. Hopefully I gave you some things to think about. If you want to connect with me and my team, easy to do, employmentlawyer.ca. Again, employmentlawyer.ca. All right, answering more questions. I'm going to continue. Sandy has our next question. Is there a legal time frame the ex-employer has to process my pension paperwork so that I can withdraw my contributions after constructive dismissal, not retirement. It's been 6 weeks. Well, if it's a constructive dismissal, your employer is going to say that they didn't dismiss you at all. Okay, so we need to force the issue. So Sandy, you're not going to be able to resolve this issue on your own, especially not with a constructive dismissal. You need to call us. Okay, we can deal with everything, your severance, your pension, your benefits. To connect with me, employmentlawyer.ca. Again, employmentlawyer.ca. All right, Julie has our next question from Facebook. Thanks for joining us, Julie. If you're terminated and accept the severance and you sign a release, can you go back and sue or file a human rights claim? Unfortunately not. That's why I'm here hammering this point that you cannot and should not ever accept that severance package. Number one, because it's likely not what you're owed. It's less than what you're owed. And number two, because once you sign it, you can't go back. You give up the right to ask for more, to pursue more, to take legal action. So no, if you've signed off on that severance package and the release, that's it. There's nothing more that you can do. There's nothing more you can ask for. Never, ever do that without speaking to me. Even if you think the offer is great, don't do it. Don't sign it. Chances are you're owed much more. It's what happens in 90% of the cases. Okay, so hopefully that makes sense, Julie. Any issues, follow-ups, again, reach out to me through employmentlawyer.ca. So let's see. Brennan has our next question. My boss calls me an independent contractor, but I think I'm an employee of this company. How does that work? So essentially, it's very simple. If you have a regular job, you go to work, you do the job, you come home, you're an employee. It doesn't matter what they call you. So if you're not really in business for yourself, but you work for someone, you're their employee, and you've been likely misclassified. So what does that mean? That means that you can decide to pursue things like overtime and vacation pay and holiday pay, etc. You can do that, and if you can do that, you go to the government through employment standards and pursue it. Where most people decide to deal with that is if you lose your job. If you lose your job, Brendan, your employer is likely going to say, no, you're an independent contractor, so we're not going to pay you anything. But because you know you're an employee, you're owed severance, meaning you're going to call me and I'll help you get that severance. Okay, so that's how that works. But you've likely been misclassified. A lot of people have. It's a very, very common thing. All right, I'm going to continue answering some questions quickly. I'm going to try to get through them all. AB1, my employer is going to pay 16 weeks of severance after 11 and a half years of service. An admin position is 16 weeks acceptable. Not even close. You're probably owed closer to a year's pay, 12 months. 16 weeks is 4 months. You're owed 3 times what your employer is saying they're going to pay you. Not even close. That's a wrongful dismissal, AB1. Here's what you do, and you do this quickly. You reach out to me in my office through employmentlawyer.ca. Again, employmentlawyer.ca. Let myself, my team help get you what you're owed, closer to a year's pay. All right, BZ Times. I work for the same company for 17 years full-time. Owner is selling a business and opening up a new one under a different name. He wants to keep me. What happens with my severance and how much? Unless you sign an employment agreement that limits your severance in the future, that seniority is going to carry through. Meaning if you continue with the company, the new company, and down the road they're going to let you go, you're still going to be owed your full severance. Now, the company may not want to do that in the future. They may try to underpay you, but you know better. So if and when you lose your job, you call me, and I'll make sure you get what you're owed. And of course, to connect with me, employmentlawyer.ca. Sonny Marvin, next question. If you're on sick leave and receiving employment insurance, can your employer terminate your employment during this period, or are they able to do so only after you receiving these benefits? So your employer should not terminate you because you're not ready to come back to work. They have to keep you employed until you're ready to come back to work and then assess whether or not there's a job for you. So if they terminate you before you're ready to come back to work, that could be a human rights violation. It's illegal. So if you lose your job, call me again, employmentlawyer.ca. Let's see. Last question for the day. Can a Jewish-owned family business have a code of conduct that states if employees are found to be participating in pro-Palestinian rallies that they would be terminated for cause? No, not really. You can terminate, but not necessarily for cause, unless, of course, you can show that by them participating in these rallies, it's impacting the workplace. Other people don't want to work with them, or customers don't want to be served by them, etc. But you can't necessarily say just by participating in these rallies, it's cause. You can say, I'm going to let you go, but you probably are still going to owe severance in that situation. Hopefully that makes sense. Again, if I didn't get to your question, because our time is up now, no problem. You can still connect with me through employmentlawyer.ca. Send an email, make a phone call. We're there for you. I answered a lot of questions today. I love them. Thank you so much for joining me. I'll be back next week, same time, same place. But don't wait until then. If you need my help, if you want to talk more about your workplace rights, if you want to resolve those workplace issues, very easy to do. You can connect with me anytime through employmentlawyer.ca. I'm Lior Samfiru, the employment lawyer. Really appreciate you taking the time to join me today and ask some questions. Hopefully you've learned something. Thanks, everyone. We'll talk to you again very soon. Bye-bye.